So long as it is not incitement to violence, there is no offense under the Indian law, right? Citizenship is in the contest these days. One of the benefits of having citizenship is that under Article 19 of the Constitution, please forgive me, I am a bookworm lawyer. So, but thankfully Constitution is in the trend these days, therefore I have no qualms going back to the Constitution. Under Article 19 of the Constitution, and only citizens that have the privileged right of free speech, right? We now say that the government has committed a great act of generosity in extending the citizenship right to a lot of other people who are otherwise not citizens thus far. So it has been marketed as a great act of generosity, but I ask myself, if it doesn't mean anything to be a citizen at all, if you cannot have your right to free speech, if you cannot have the right to free speech, then what is the point in being a citizen? What are we fighting about? Right, so this question of defending Sharjeel's speech, right? It's not because he said something or he didn't say something else or whatnot, but it is because we have the right to free speech and we value citizenship. Interestingly, under the Indian Constitution, we have Articles 5 to 11 that talk about citizenship, and the state comes only at Article 12, right? So we were citizens before the state was state. In the state trying to control our rights as citizens, including by enacting laws or retaining laws, colonial laws, which were like Section 124A of the Indian Penal Code. What it is effectively doing is inverting the priorities that the Constitution gave both to us and to the state. Section 124A, as you might have all known, has been read down by the Supreme Court in 1962 in a celebrated judgment, Kedarnath versus the state of Bihar. A 5-judge bench of the Supreme Court laid down that unless there is an express incitement to violence, right? Incitement is not even just call for violence. Unless there is express incitement where the situation was right there and the speech itself was like the spark in the powder keg, and that is the threshold for incitement. Unless a speech qualifies as such clear and present danger to incite violence, there can be no offense made out, right? So this was in 1962. 1962 was when our fundamental rights jurisprudence had not even developed. It had not developed certainly like the way it is now. In the 1970s, through the 80s, and through the following decades, not just in India, but across the world, we have fundamental rights jurisprudence, and the human rights jurisprudence has significantly evolved and advanced. And this has been recognized in a number of our own judgments. And there are several doctrines, for example, a chilling effect. I'm sure you'd have heard about the phrase chilling effect, right? So when a state makes laws such that there is a psychological impact on you yourself curb speech. For instance, it is certainly something that we hear all the time where people say, don't say this on Twitter, right? So Modi is watching you, right? Right? So, or Snoopendra has logged in, right? So these are what we call chilling effects, where just mere the fact that there is this law exists on the statute book is sufficient to cause self-regulation in people, and that is chilling effect, and this was not even considered. So now, under our constitutional jurisprudence, we now recognize that laws that cause chilling effect are unconstitutional per se, right? This this is something that was not even recognized in 1962. Right? And we've had several judgments now. I mean, in 1962, how we read fundamental rights was that Article 21, personal liberty, was a separate fundamental right. It had no overlap with Article 19, which was right to free speech, right to freely move through the country, right to peaceably assemble, etc. So these were thought of as completely different silos, and which is one of the reasons why in 1960s and earlier in the 1950s even right to privacy was held not to be a fundamental right. That changed significantly later. In 1970, 11-judge bench of the Supreme Court held that this is not how we read fundamental rights. Fundamental rights are value statements. They have overlapping zones among them, and we need to therefore give what is called a synoptic reading of all of these fundamental rights and understand the fundamental rights as value statements and philosophical statements, right? And that is why in 2017 we had the landmark judgment where nine judges unanimously held that right to privacy was a fundamental right on a conjoint reading of Article 14, 19, 21 and other rights in the Constitution. So we've had a sea change in our fundamental rights jurisprudence. Maybe it is a good time for us to go take these challenges to the Supreme Court and relitigate this and say 124A to be held to be unconstitutional, not just merely read down to say that only that speech that incites violence is seditious, right? There's no such in a modern democracy where the legitimacy of the state is not because it is colonial power. It is not the legitimacy of the state. Legitimacy is derived from popular democracy, right? In a colonial setting, it was not so, and that is why sedition even had its meaning. Right? Theoretically, a state that derives legitimacy because it is popularly, democratically elected, its legitimacy should stay on surer footing and not on seditious speech. Before I give it to Professor, the last thing I want to state is that there's a lot of talk about fundamental duties, that duties as citizens. Lots of dogs barking at us saying that not only rights important, but duties are important as well, right? Yeah, but what are those duties? Right? Well, what are those duties, right? So those duties are not only those duties enumerated in 51A of the Constitution, where you say you need to be singing the national song, the national anthem, you need to stand up to your national anthem, you need to develop a scientific temper, and right? But there are duties intrinsic in our rights. Article 19 is conferred on citizens not because you have a right to free speech, also because you have a right to free speech, but free speech is the way to keep our republic a democratic republic. And that is a duty cast upon us as citizens. Therefore, when I say this is solidarity with Sharjeel Imam, it's not something that, it's not a great act of generosity or charity that we do here. We are only upholding our basal duties as Indian citizens. We have a duty to keep this republic a democratic republic, and let us do it. Thank you very much.
Thank you.